All right, the court will call the case of the Ranches of Rosebrook versus A Nice Battle, case number 25C 1245.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Ms. Battle, please hit star 6, unmute your device and state.
Hello? Hello?
Please state.
It's a niece battle on a special appearance for the record to contest the jurisdiction and the facts for this court.
Yep. All right. Well, Ms. Battle, I'll tell you that this matter is appropriately in the correct court. The court does have jurisdiction.
And it's based on what? What is on the record that is based on that the court has jurisdiction?
The fact that this is a case that is within the jurisdiction of the Township of Ypsilanti, and if you have issues related to any contracts, that would be within this jurisdiction as well. So all of that is within the jurisdiction of this court.
So you're saying that the contract is in jurisdiction of the court?
That is what I just said, ma'am.
All right, and the contract has been rescinded. So how is the contract in the jurisdiction of the court if it's invalid?
Who gets to rescind a contract on their own? That's
what are you talking about? I have the right to rescind a contract by right of common law.
Ms. Battle,
that doesn't involve court.
Ma'am, you need to stop talking or you're going to get held in contempt of court. Mr. Fantier, have you had a chance to talk to Ms. Battle? I talk to Ms.
You're breaking up. I can't hear you.
Mr. Fantera, do you need to speak with her, or are we ready to speak?
If you want me to speak to her, I'll speak to her. You know, I mean, she talks about rescinding the contract. Does that mean she's moving out?
All right, buckle up, because today's video is basically a greatest hits compilation of sovereign citizen nonsense, spread across 4 different courtrooms for different judges, and 4 wildly different flavors of legal fantasy. What ties them all together is the same core belief, that somehow by saying the right magic words, reality just stops applying to them. That we're kicking things off in Judge Washington's courtroom with an eviction case that should be painfully simple. Tenant doesn't pay rent, landlord files for eviction, court decides. Except here, the tenant insists she isn't actually a legal person, claims the contract magically vanished, and believes that saying "I do not consent to jurisdiction" is the legal equivalent of an invisibility cloak. And that's just case number 1. We've also got a felony defendant facing real prison time who thinks Google research and vibes can replace an attorney. Then we head into a drug case where basic counting becomes a struggle. Across all 4 cases you'll see the same patterns. Talking over judges, misusing legal terms, and absolute confidence paired with zero understanding. So watch closely, not just for the entertainment but because these cases perfectly show how fast courtroom bravado collapses when it runs into actual law.
I'm sorry, you're breaking up.
Are you moving out?
Are you moving out?
No. Why would I have to move out?
Because if you rescind a contract, you're okay, fine. Your Honor, I think we just set this for trial.
Okay. One moment.
This case has also been in the, it's in the circuit court. A petition filed for an injunction. I did serve you all. It is set on the 30th.
Yes, ma'am, I heard.
We're aware.
Okay. And once again, I do not submit to the jurisdiction of the court. The contract is rescinded.
So how can the contract?
And I am not a legal person.
You're not a legal person?
How can a contract? No, I'm not a legal person. I'm not a legal entity. No, I am not. And you have to prove that on the record.
Actually, I don't.
I'm sorry?
Can I ask Ms. Battle a question, Your Honor, real quick?
Sure.
So, Ms. Battle, so you can live there forever without paying rent because you're not a legal person?
That's not what I'm saying, but the contract itself is invalid. I'm saying that you don't have any personal or subject matter jurisdiction over me. Over an invalid contract, no. And over me not having a legal capacity to be sued, yes. So if that's how you want to take it, then that's how you have to take it. But that's what's lawful, and that's what's written in the law.
Let me just tell you, I think you're wrong on both counts. I would expect that we would.
It's okay for you to think that I'm wrong, but the facts still align with what I'm saying.
Okay, Your Honor, I think we should have a trial.
You have to prove without the reasonable doubt. So let the record show that the judge has not required the plaintiff to prove without a reasonable doubt that I am a legal person, and it's on the record, not assumed, not presumed, on the record. There's nothing that's on the record that states.
Ms. Battle, first of all, reasonable doubt is a standard in a criminal case, not a civil case. So I do not have to prove anything beyond a reasonable doubt.
Sarah, I need both of you to stop talking, please. Both of you, I'm sorry. I cannot figure out the date because I can't hear over the two of you.
I apologize. I didn't know that's what you were doing, Your Honor.
This matter will be scheduled for May 6th at 3 p.m. for a trial on any and all issues that may be before the court. Ms. Battle, if you have anything else that you need to say, you can unmute yourself by hitting *6 to do that.
Okay, I just find it ironic that I got muted when I was speaking on jurisdiction and how there was a lack thereof on the record. So I want that to be on the record. But I also wanted to, okay, that's fine. And I also wanted to be on the record that I am not going to be able to show up on May the 6th. So it's also ironic that you are able to verify with him that he's able to show up, but not with myself.
I just asked you that, and you are now talking about something else. Why can't you do this?
That's because you cut me off and put me inside of a break room and muted my mic instead of allowing me to speak on what needs to be spoken on.
All right, this is set for May 6th at 3.
Your Honor, by Zoom? By Zoom?
Correct.
All right. Thank you, Your Honor.
It's ridiculous. This is a fraud upon the court. Goodbye.
This is where the sovereign citizen script really kicks in. You'll notice the buzzwords start flying fast. Rescinded contract, common law, jurisdiction, all delivered with total confidence, and absolutely no legal grounding. What she's attempting here is a classic maneuver. If the contract is invalid, then the court must be invalid, and therefore none of this applies to her. The problem is that contracts don't just evaporate because one party declares them rescinded, especially not leases. Courts exist precisely to resolve disputes about contracts, including whether they're valid, breached, or enforceable. You don't get to be the judge, jury, and appellate court just by asserting it loudly. Judges hear this argument constantly, which is why Judge Washington shuts it down immediately. Jurisdiction isn't optional, and you don't opt out of it like a mailing list. This case is already filed, the court has authority, and no amount of pseudo-legal phrasing changes that.
All right, this is in the matter of the people of the state of Michigan versus Shane Leroy Reamer, file number 23-216665FH. This is the date and time set for a final pretrial conference. Today was the motion deadline for both motions and motion in limines to be heard. Jury instructions were to be provided to the court by April 2nd, along with any proposed voir dire questions. We are set for trial on April 22nd of 2025. Mr. Reamer, you are charged with police officer resisting and obstructing causing injury, which carries a maximum penalty of up to 4 years in prison. Police officer assaulting, resisting, and obstructing, that carries up to 2 years in prison. There's 2 of those. And then there's a disorderly. And what is the plea offer in this file?
Your Honor, the people have offered to a plea of 2 counts to attempted R&O.
All right.
So 2 misdemeanors, and we would kill a brute to no upfront jail.
All right. Mr. Reamer, the plea offer in this case was to plead to 2 one-year misdemeanors with no upfront jail, and there'd be like 12 months or so of probation and some minimal fines and costs. Do you understand that? All right. Now, Mr. Reamer, you know, I'm assuming you graduated from high school, right?
8th grade.
You went through 8th grade, and this is a felony that could result in you going to prison. Why don't you stand in front of that podium for me? So do you understand an attorney can help guide you through the legal process?
Yes, I tried to have, I almost had a public defender. Unfortunately, she wasn't representing me appropriately. I'd asked for another one, but.
So I have no authority over who gets appointed. You're appointed an attorney.
I understand that, but when they're not representing you appropriately.
Okay, I didn't ask that. I'm just saying you have a right to an attorney. I know the attorney you're referring to. She's diligent. She works hard. Maybe you didn't like, I know when I was a public defender, sometimes my clients didn't like what listen to me, I'm talking. My clients didn't like the things that I told them. But, you know, her job isn't to do what you want. Her job is to represent the law. So you understand at this point, you can hire an attorney, or you can go with the public defender and whoever they assign you, or you can go to trial pro per with no law degree, no experience, and risk going to prison. You're gonna represent yourself.
I'm gonna represent I ain't got no choice but to represent.
And here it is, the sovereign citizen word salad in its purest form. Strawman. Allodial title. Treaty of Peace and Friendship. USC UCC estate holder. It sounds impressive if you've never taken a law class and learned everything from TikTok videos filmed in pickup trucks. What's actually happening is deflection. Instead of answering the very simple question, are you moving out? She launches into a fantasy framework where she exists in some parallel legal universe. Judges aren't confused by this. They're just waiting for the sentence to end so they can get back to reality. Notice how the judge doesn't argue doctrine or debate imaginary treaties. She cuts straight to the practical issue. Courts don't care about made-up sovereignty theories, they care about possession, rent, and compliance. And every time a defendant avoids a direct answer, it only speeds things toward trial or eviction.
Did your jury question, the voir dire questions? Because if you haven't, they're waived.
If there's
No, they were due.
If there's evidence provided against me, I have a right to defend myself using that very same.
That wasn't the question I asked you.
That's
You do have
exactly-
a right to defend yourself, Mr. Raymer. I'm just.
My right for violence.
I'm talking, you're not. If you don't stop talking and listen to me so I can go through my speech, I will send you over to the jail. Do you understand? All right. You have not filed any motions. Jury instructions were due and voir dire questions were due. You have not provided those. We gave you a copy of this. So do you understand what I've received is what will be used? Yes or no?
I will be allowed to ask my questions.
What question?
When I'm cross-examining, I will get my.
I'm talking about juror question. I'm talking about jury instructions and voir dire questions. You understand now? You
I don't
didn't file,
understand.
listen, I know, but you waived that because you have not provided them. Do you understand that? Do you understand that?
No, I don't. I don't
Okay.
understand that. I didn't understand that.
Okay, well, I
That's why
can't
I'm-
advise you of the law because I'm not an attorney, I'm a judge.
No, but you're
So,
looking at the case and you've been presiding over my case for 3 years now.
I know, it's fine. You're
the one-
gonna go to
You're the one
trial.
that signed the warrant for my arrest while I was in jail.
I don't know that, I don't
Yes,
remember.
you did do that.
Okay, I'm allowed to do that.
No, you violated my rights of privacy.
Okay, well, you have options. You can file a complaint with the JTC if you'd like. So are you prepared to go to trial?
Absolutely.
Have you provided your witness list?
I haven't yet, but I will.
Okay, that was due.
My witness list was provided when, Ms. Underwood was my attorney.
Okay,
And my witness list is.
have you subpoenaed any witnesses that were not on the prosecutor's raised just eyewitness list?
Yes, my witnesses are the ones that was there at the scene.
No.
And
Do
yes,
you understand that you have to provide a witness list and you have to provide a copy to the prosecutor? Do you understand that?
prosecutor, I gotta provide what to him?
So if you're gonna have witnesses at trial, you need to make sure the prosecutor has their name and contact information so that they could interview them prior to trial if they wanted. Do you understand
Well,
that?
they got all that information.
They do?
Yes.
Okay,
Yes,
so,
my witnesses are my parents and my aunt.
This is a huge tell for anyone watching closely. The moment she demands proof beyond a reasonable doubt, she exposes that she doesn't understand the most basic difference between criminal and civil law. Evictions are civil matters. There's no jury deciding guilt. There's no constitutional burden of proof at that level. Sovereign citizens often mix criminal standards into civil cases because it sounds authoritative. But it's completely wrong, and judges shut it down every time. You can hear the patience thinning here. The judge explains the rule, issues a scheduling order, and moves forward despite the noise. Courts don't need to prove you're a legal person. If you signed a lease, live at the property, and are before the court, congratulations. Jurisdiction achieved. The law doesn't collapse just because someone refuses to acknowledge it. Clip 3. This accusation right here is projection at its finest. When sovereign arguments fail, the fallback is always the same. Claim fraud, corruption, or conspiracy. It's easier than admitting the case is straightforward and unwinnable. What's really happening is delay. Eviction cases move slowly, and some tenants exploit that by flooding the record with nonsense. They know they'll eventually lose, but every extra week of rent-free living feels like a victory. Judges recognize this pattern instantly, which is why this case gets pushed to trial without indulging the theatrics. The court isn't confused. It's not rattled. It's simply moving the case forward, step by step, while the defendant talks herself into a guaranteed loss.
okay, I don't know. Are those on, if they're not on the people's witness?
Curtis,
I'm not
Penny,
sure.
Okay,
Rose.
if you haven't provided a witness list and they're not on the people's list, you understand you won't be able to call them.
Okay, I will provide the information. I
Okay.
will provide that information. Yeah.
I'm just telling you. So you need to make sure that there's a witness list in the file that was provided to the people.
So I gotta re-provide it.
I don't know. Go back and look at what witness list has been filed,
filed.
their name, their contact information, and then any subpoenas you have to do. If you have to subpoena anybody to be present, you need to get those filed this week. And then the court signs them, and then you serve those people with those. Do you understand? Now, do you understand when we go to trial, a lot of times some of the questions you ask or he asks may be objected to, and it's not personal. It's just, we have to follow the law.
Yeah.
Okay.
I'm allowed to object too though, right?
Huh?
I'm allowed to object too.
You are, and then you have to provide the basis for that objection. Okay, so you need to understand your objections. So you might want to do some research to understand.
I've been doing.
Good. You sure you don't want a public defender for trial?
Huh?
You sure you don't want an attorney for trial?
I'm not gonna take any of the attorneys from here because they're all corrupt.
This is one of the most dangerous moments in the entire video. The judge is bending over backwards to help this man understand what's at stake, real prison time, and he's still convinced that representing himself is somehow safer than accepting a trained attorney. This isn't confidence. It's Dunning-Kruger in a courtroom. He doesn't understand motions, jury instructions, evidentiary rules, or deadlines, and the record shows he's already missed several. Judges can't help him, prosecutors won't help him, and the law won't slow down for him. Self-representation isn't bravery. In felony cases, it's usually a fast track to conviction. And once trial starts, it's too late to undo the damage.
What is your name?
I am Brian. My family name is Wilkinson.
All right. We'll go on the record in State of Kansas versus Brian J. Wilkinson. Case number 25 CR 67. The state appears by County Attorney Darren DeVinny. Mr. Wilkinson appears in person by Zoom. We're here for a first appearance. Mr. Wilkinson, you're appearing by a summons. I'm going to go over your charges with you. There are 3 counts, all alleged to have occurred on June 4th, 2024 in Butler County, Kansas. Count 1 alleges you were in unlawful possession of methamphetamine. That is a level 5 drug felony. Count 2 alleges you are in unlawful possession of paraphernalia for use. That is a Class B non-person misdemeanor. Count 3 is an allegation of possession of marijuana, also a Class B non-person misdemeanor. Do you understand what you've been charged with, Mr. Wilkinson?
I do not understand, Your Honor.
Okay, what don't you understand?
I had thought that this matter was already settled on the case that Mr. Watts was representing me for.
Okay, I'm not aware of that particular matter. That may have been a different case. I'm not sure.
Well, there wasn't a different case. I mean, I wasn't attacked and assaulted and kidnapped 2 different times, just one time.
This line connects every case in today's video. Sovereign citizens don't distrust just courts. They distrust every system that contradicts them. Judges are corrupt. Lawyers are corrupt. Science is corrupt. Evidence is fake. Why? Because if the entire world is rigged, then personal failure isn't the explanation. Accountability disappears. The problem isn't the argument, it's the system. And that mindset makes courtroom outcomes completely predictable. Judges don't debate conspiracies. They apply law. And no amount of belief can override statutes, procedure, or evidence.
Mr. DeVinny, do you know anything about another case involving Mr. Wilkinson?
Let's see. Well, I know that his criminal history, I know he's a B on the grid. He has out of at least Butler County cases, we've got a driving while suspended, an old a 23 traffic case that's closed. And then he has this open case now for possession of methamphetamine.
Do you know of, is there one where Mr. Watts representing that you know of?
Not that I'm aware of. Well, Your Honor.
All right, well, I don't know, Mr. Wilkinson, that can be sorted out. Can you afford to hire an attorney to represent you?
I'm sui juris.
Excuse me?
I'm sui juris, and I would appreciate it, Your Honor, if you would recite your oath of office, your delegation of authority order, and your bond information.
I'm not going to do that, Mr. Wilkinson. Can you afford to hire an attorney?
I am not a ward of the court. I'm not an idiot. I know how to speak for myself.
Okay. Do you wish to represent yourself?
Well, I am myself. I can't represent myself, but yes, I will be talking for myself.
All right. You understand you have a right to have an attorney represent you on this case?
Yeah, but that makes me a ward of the court. If I am seen as too stupid to talk for myself. Do
you understand that if you can't afford an attorney to represent you, one would be appointed for you?
I also understand that all attorneys' first duty is for the court and not for.
Across all 4 courtrooms, the pattern is crystal clear. Different charges, different judges, same result. Sovereign citizen arguments don't confuse courts. They waste time, burn credibility, and make outcomes worse for the people using them. Whether it's an eviction, a felony assault charge, or drug possession, the law doesn't bend to ideology. Every judge here gave opportunities to comply, to clarify, and to get legal help. And every defendant chose defiance instead. That's why these cases move the way they do, quickly, decisively, and without sympathy once the nonsense starts. If you found this case as shocking, or as frustrating, as we did, hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns just like this. We'll see you in the next one.
Do you understand you have that right, Mr. Wilkinson?
I do understand my rights, yes.
Okay.
Your Honor.
I'm going to go ahead and appoint James Watts to represent you if you think that he's represented you on something that may be in line with this case. So he'll be with you when you appear back in front of me, and that'll be on my preliminary hearing control docket. Do you have something to write with, Mr.
Yes,
Wilkinson?
sir.
All right. Your court date will be in front of me by Zoom on May the 19th at 2:30.
May 19th, 2:30 p.m.
That's correct. Do you have Mr. Watts' contact information?
Yes, I do, Your Honor.
You might contact his office and let them know that court date. We need to set a bond. Mr. Devaney, what's your recommendation for bond?
The defendant does appear here voluntarily by summons here today, so I'd request a $10,000 OR bond for the defendant.
What was the amount?
$10,000.
All right, I'll set a $10,000 OR bond. He'll need to be processed, I'm assuming.
Well, he initially had a first appearance back on June 5th of 24 at 1:30. At that point, we were waiting on KBI Labs and we released him. So I believe he's actually been arrested and processed.
Okay.
He just needs to come to 201 West Pine. If he can make it here today before 5, that's great. If not, probably on Monday to come up to the front desk so he can sign his bond.
All right. Mr. Wilkinson, can you make it up to the Judicial Center this afternoon to sign your OR bond?
It'll probably need to be Monday, Your Honor.